So wait, hold on. There's a possibility the service might be interrupted again for a couple of minutes. Okay. Okay. Please. I hope it's not. Yeah. There's about 100 people here right now that hope it's not going to get interrupted. Okay. Excellent. Excellent. Thank you so much. To bring my old modem to replace it with a new modem. Okay. Thank you. I really appreciate everything you're doing right now, but I really don't have time for it. I did mention I was kind of in the middle of trying to do something. Yeah. Okay. Yeah. I'm fine with the mobile carrier. I really appreciate it. I've had that on my I've had that offer on my bill now for well over a year and passing it. So thank you. Yeah. Okay. That's it. Thank you. Thank you, Brian. Happy holidays. Bye-bye. And ladies and gentlemen, we are live with some court. I can't believe I'm actually saying this. We can't do this very long, but I wanted y'all to at least see a few of these cases. So I'm hitting play now, and I'm going to go away because I want to scream loudly. I just want to scream loudly. That's all there is to it. I hope you all understand. This has been a painful process for me. The internet is now back online temporarily. Apparently, I have to go pick up a new modem tomorrow, and Lord only knows if we'll have any content to view. So, again, thank you for showing up and showing out, ladies and gentlemen. I appreciate you. I'm your Lone Wolf Usul, and we're getting back into the court videos. Here we go.
I have
People against Blake, Maurice, Moral the third, 25B 7279151FY.
Mike Baldwin, arraignment attorney. Judge, today's the date and time set for arraignment. For purposes of arraignment, my client stands mute and waives formal reading of the general information.
Sir, your name?
Blake Maurice Morrow.
All right, good morning, Mr. Morrow, or afternoon, I suppose now. I'm going to go ahead and arraign you. Your lawyer indicates you stand mute. You have a charge of home invasion in the second degree, which is a 15-year felony and larceny in a building. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. The probable cause conference will take place 1 week from tomorrow, which is the 23rd of December. And the preliminary exam will be December 30. Let me go down here December 16th at 9:45 for the PCC. And then December 23rd for the exam. I'm arraigning a felon right now. Well, they must have just made a mistake, right? The 16th tomorrow. So I mean, prosecutor's office is still going to be here both those days, right? Okay. Thanks. Okay, so I'm going to do the 23rd at 10 o'clock. Preliminary exam will be the 30th. At 11 o'clock. All right, now we're going to address bond. What do you have to say?
Very briefly, Judge, my client's 20 years of age. He's going to be 21 in January of next year. He works at Anthony Pierce Concrete. He's a laborer. He's a seasonal layoff at this time. He is taking care of his minor niece who lives with him. He is a resident of Monroe. He also resides with his girlfriend, the client's girlfriend, who has 2 minor children as well. His highest level of education is the 11th grade. He has no additional credentials. However, he is certified as a high-load operator and pallet jack operations. He was born and raised in the Detroit area, and he does not hold a valid driver's license. He's never acquired.
Detective, what can you tell me about this? Was there any kind of relationship between the defendant and the victim here?
I believe it.
Your Honor, to my knowledge, I believe they are related. We're sister and brother. Sister and brother, Your Honor. I have text.
Sir, you shouldn't say anything, sir. Okay? You shouldn't say anything. Do you want to add anything else? Do you know what this was regarding, Detective?
Your Honor, it was regarding stolen property. This is Detective Tulot's case. She wanted me to make note that there is some criminal history out of Ohio. Nothing out of Michigan here.
Where does he work?
Our victim in the case, our victim in the case does not want any contact and has since moved from her address that's originally listed in this warrant recommendation.
And that's in the advice of rights. His new address and phone number is in the advice of rights. That's updated.
So he wasn't living with her at the time. He just broke in and had the intent to commit a larceny. Am I reading this right?
I believe so, Your Honor.
20,000, 10%. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with Sim and Warren. No contact with prosecution witnesses. You cannot enter 22910 Bernice Court in Brownstown, no marijuana, no alcohol, no illegal drugs. You're not to possess firearms or dangerous weapons. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We will see you here next Tuesday. You have to post $2,000 to secure your release, okay?
May I say something on behalf of my client at his request, realizing we had factored in that the bond was going to be in this area? Would Your Honor consider a lower bond with a GPS tether?
Where does he's a seasonal employee.
He is laid off, but what he does is he does concrete laying during the season. He is a lifelong resident, Judge, of the state of Michigan. He was born and raised in the Detroit area. He is taking care of his daughter, who's 7 years old. He's the main support.
That's him. That's me. That's my niece. That's the other client I'm being told here.
So if Your Honor would consider a GPS tether, that would be a big difference for him to be able to get out and take care of these children that he's. He's also
How much
licensed.
can he post? Can he post 10? Can he post 1,000?
I did speak to, can you post 1,000? It's your lawyer.
Honestly, I gotta call my stepdad. I gotta.
10,000, 10%. Hang on. I'll not to be released until fitted with a GPS tether. Not to be released until fitted with a GPS tether, and you're not to be within 2 miles of the victim, her residence, or place of employment. So I'll reduce it. I'll go down to 10,000, 10%. So you have to post $1,000. Wish you well. Thank you. Good luck. Bring in Mr. Whittle now, please. This is Timothy Jamie Whittle, 25B148379A, 25B148379B and C. And I got 21F235726A. And I've got 25T645972A, 20B137133A, and 20B137080B.
For the record, Your Honor, arraignment attorney Mike Baldwin, he's 65417 on behalf of Mr. Timothy Whittle on all of these files. For purposes of arraignment, my client stands mute and waives formal reading of the general information and complaint. His updated address and phone number and an advice of rights in each one of the files.
Tell me your name, Mr. Whittle.
Timothy Jamie Whittle.
It's going to take me some minutes to mark these up. I don't even want to say anything right now. You must be a big shot, though.
Just trying.
I'm just telling you, you must be a big shot. I mean, you must be running the you must be the Secretary of State, Chief of Staff to the President, something important. I mean, you have to be really, really, really important. You have to be. Because there's no way that somebody would not show up unless they're doing something really, really important. So we're going to find out what that is, and then I'm going to proceed accordingly here. But you do not, Mr. Whittle, you do not endear yourself to any judge in the country by acting like this. Do we understand one another?
I understand.
This is the old cases we talked about, Mr. Whittle, you and I as your attorney.
I mean, I'm so curious as to what he does for a living.
I
want to do something that important. I mean, you have to be important. I mean, minimum, you're an athlete making $222 million over 4 years. I don't know if you're a shortstop pitcher. I don't know if you're a guard in the NBA. I have no idea. But you have to be doing something so incredibly important that would cause you to not show up. And I'm just getting started here. I mean, I want you to know that. We're going to have some fun now, Mr. Whittle. Who do you think you are? Who do you think you are? And guess what? I don't care if you make 50 million bucks a year as a professional athlete. I don't care if you're Secretary of State. I don't know who you think you are. It's amazing. I mean, you have just managed to prove you got to be doing something important. You got to be doing something really, really important. I want to repeat myself 19 times before I set your bond. I mean, you picked the wrong guy to play this kind of nonsense with. I need some white on. I mean, I'm just always amazed. Just completely amazed that people think they can do this. Now, so he stands mute on all these cases, right? He's got at least 7 of them.
He has 7, Judge. He does stand mute, waits formal reading of the general information complaint. I've gone over each of the general information with the client. I will note he's had bonds. They've been forfeited. There's been financial bonds in the file that have been worked.
No. We have the audacity to forfeit bonds? Are you kidding? Are you kidding me? We did that? Guys like, people like us did that? You must be bad over here. Tell me what he does for a living. I'm
Thank you,
curious.
Judge.
Tell me. Is he an
Yes, he
all-star?
works at Sam's Club, Judge, in
Sam's
Kenton,
Club.
Michigan.
Sam's Club. Okay.
Yes, he's also.
I thought he owned all Sam's Clubs to act like this, but go ahead.
He's also enrolled in Washington Community College. He starts.
Why would he do that? Why would he do that?
To better himself.
I feel like setting this case with a bond and setting it for like, he's got a 2020 case he pled guilty on March 5 of 20. He didn't show up on that 3 or 4 times, then didn't show up for his sentencing in December 21, then posted a bond. And then on April 26 of 23, he didn't bother showing up. Then it looks like he posted another bond. Let's see. And then, or somehow we canceled the warrant. I don't know what happened. Then August 13th, he didn't show up of 25. That's just on one case. On the other case from 2020, March of 20, we never even adjudicated that. He didn't show up for pretrials after forfeiting bonds and not showing up. And another case we had here out of the metropolis of Trenton where he didn't show up in August or for the show cause on the second time. And then he had other cases out of Brownstown, possession of controlled substance, that he didn't show up with from 21. And then another one out of Brownstown. Yeah, same thing, suspend and false information. And, so I just want you to know this does not enthuse me, because this just tells me flat out that somebody's just plain out, flat out arrogant. That's what it tells me. But I won't belabor the point. You can go on and tell me, because he's going to be sitting in jail. I mean, I don't know what kind of bonds I'd have to set. He'll post and then he won't show up again, like a fugitive. You want to be a fugitive, Mr. Whittle?
Your Honor, I promise I'll show. If you show any type of grace on me today, I promise I'll show.
Don't, listen, listen. Show grace on you. Give me a break. I have a mind to set about 10,000 in bonds and set this for 2027. Show grace. Why would you deserve any grace or compassion out of a judge when you've been thumbing your nose at this place for 5 years? You tell me why any judge worth 14 cents would grant you any kind of compassion.
I have no excuse, Your Honor. You got no reason to believe anything I say.
I don't, okay, all right. Now you're gonna cry. I always think, like, if you're gonna act like a fugitive, take it like a man at least. I hate that. Now you're gonna cry. Now you're gonna cry. Wah, wah.
It just wasn't my intention. I never did it purposely.
I just hate that, Mr. Baldwin. I'm sorry.
It's okay, Judge.
I'm just-
to the files as well. I understand.
I just don't understand this. I just will never understand this. But I'm not gonna set this out like that. I don't do that thing. I'm gonna be more fair with you. On A379A, 10,000, A, B, and C, 10,000, 10%. On 21F, 235-726A, 6,000, 10%. On 25T 645-972A, $2,500, 10%. On 7133A, 2,500, 10%. And on 20B 137080B, 2,500, 10%. I don't even know what that comes out to, but I'll give you early court dates. I will do that for you. So you need 250, 500, 750, 1750. And what's the other one I said here? Yeah, 2350. Looks like 2350. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm going to give you early court dates. I'm going to be more fair with you. So we're going to give you December the 17th on the Brownstown cases. December 17th at 10:30 in the morning. So you're going to only be sitting in there for 2 days if you can't post.
Would that be for all 5, Judge?
Well, I got to check that. I'm double checking that right now because I don't believe.
He's got 1 Flat Rock, 1 Trenton, and
Yeah, the Browns.
5 Browns.
Looks like they're giving me different dates for. Then I'm giving you December 18th at 10 o'clock on the other Brownstown cases. And then on the other case, I thought there was one out of Trenton.
There is 25T 645-972A DWLS.
That's the one that's, jeez, oh, people. Yeah, that's December 18th at 10. That's the one out of Trenton. And then on Brownstown, I think we're doing all Brownstown on the 17th.
Okay, good.
And then Trenton on the 18th. And
Flat.
Flat Rock on the 17th. Flat Rock on the 17th. All right.
Yep.
I bet you missed no less than 25 times on these. I don't know what the problem is, but good luck.
Thank you.
Ms. Demeter, could you come on the Zoom call, please?
Yes,
If
Your
you're
Honor.
available.
Well, I'm going to give people a choice here. We're picking up into Thurston County's anti-harassment calendar. A lot of people may have already seen this, but I'm willing to play. Here's the big question. Do we just play it out because there's about an hour and a half left, or do we skip over to, say, Middleton? I don't know. I'm kind of leaving it up to chat. I know Marty's seen this. And, yeah. What do we think? Kieran? Boy says Middleton. Let's see if I can even pull that off. Up, 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 up. All right. We'll pass on the anti-harassment for now. We'll save anti-harassment. We may do anti-harassment on our live Saturday. We may do it as just a standalone video. We'll figure it out later. For now, we're on to Middleton, and Blackboard is live.
Come back, man, if there's any other problems. All right, let's next make a record on James Jonathan Harvey. This is file 25366SM. This is a domestic violence case. Mr. John Bush is here. Mr. Harvey is not. Also present is Angelique Canfield from the prosecutor's office. This was a sort of an odd plea deal that was made before Ms. Canfield got here. The defendant was charged with domestic violence. The prosecutor agreed. This has only happened twice. I think today's two cases. We never did this before, and I don't think we've done it since in domestic violence cases. But it was deferred with the thought that Mr. Harvey would be coming into the sobriety court treatment program. And he's in that program. As I said before we went on the record, he's had his ups and downs. He had a relapse. I put him in jail for a few days. He took his lumps. He's back in the program. He isn't here today. This was set in June for sentence in December. I suspect he just didn't remember he's supposed to be here. His next sobriety court session isn't until January. His probation officer, Autumn Kiefer, is in regular contact with him. So what I would propose to do here, Mr. Bush, is, well, first of all, Ms. Canfield, what's the prosecutor's position on this?
Well, Your Honor, the information in the file was that if he would seek a substance abuse evaluation and mental health counseling, sign releases, take medication as prescribed, and follow the recommendations of the evaluations, and was compliant with all of those conditions, and it would be reduced to a disturbing the peace today at sentencing. I don't know that those things have been completed, but through the drunk driving sobriety court matter. I do have access to some of those documents. I do know, as one of the prosecutors who attends the sobriety court as well, that there was a time in twice in October, I believe, one where Mr. Harvey missed his test on a Friday, and another where over that weekend he admitted going out with a client and getting
good
drunk.
Yeah.
So in my mind, although those don't lead necessarily to new criminal charges, those were violations of his drunk driving probation. They are a violation of lack of compliance here and following those recommendations of remaining sober. We do know that addicts obviously have those falls off the wagon at certain times, and obviously he did, and he admitted it, and he did a sanction. I'm reluctant to do a disturbing the peace without having more information about whether any of his therapeutic process is also addressing triggers to violence and not just alcohol, which I think he could be doing in his individual sessions. I just don't know. So I need a little more information in that respect.
And victim input may be helpful also. I think the parties are back together, and I do believe he's back with the complainant. The normal course of events is I would do a bench warrant, but I don't think he purposely, I just think he's following his pattern of not having his ducks in a row. So I'm gonna reset this sentence. I don't yet know where I'm gonna put this, Mr. Bush. I'll have to look at your calendar and the court calendar. I'd rather do it before the end of the year, but there's not very many court days between now and the end of the year. And in the meantime, I'm gonna have his probation officer get in contact with him and tell him he missed court today.
Do you have access? I'm just curious if you have the same address that I have, or is that not part of the file?
Well, I have the Douglas Avenue address.
I have a Javier Drive address as well.
He's not at Javier Drive. That's where the girl is, and he's not on the lease. I think he spends a lot of time there, but I don't believe that's his actual address. We'll contact him through the probation department. All right, Mr. Bush, thank you.
Judge.
And just to dot an I and cross a T, Everett Valancourt was set for sentencing this morning on operating while intoxicated with a prior offense. Mr. Gibson contacted the court and prosecutor earlier. The defendant has allegedly the stomach flu, and so prosecutors agreed to adjourn this. There's somewhere floating around a stipulation to adjourn. I know the stomach flu was going around here at the courthouse. We don't want it, so we'll reschedule.
Just to follow up with that, Your Honor, I did have my staff print, and I signed that stipulation to adjourn, so it should be coming to the court shortly.
And again, we'll have to find a place to put that. All right. Next up is the matter of People versus Kevin Michael Engelmeyer. File number is 25513SM. Mr. Engelmeyer is here with his lawyer, Mr. Ross Truckee. This is another one that I wasn't completely clear on where we are here today. We did have some discussion before we went on the record with Ms. Camfield and Mr. Truckee, who's got a good handle on this. This is another case that was, the defendant was charged with domestic assault. It's alleged that on March 21st, he assaulted Vicky Harbison, who was his sister. He actually broke some bones in her face, charged with aggravated domestic assault. She threw his phone out the window of the car and he hit her in the face. She had to get some reconstruction. He then was charged with violation of bond conditions. Well, first of all, that was, darn it, this stuff's hard to negotiate. Well, what the heck? There was an order delaying the sentence. Defendant pled guilty to misdemeanor domestic violence down from aggravated domestic violence. And the county had agreed to a deferral. And as I said, we haven't really done these. We've done domestic violence deferrals, but not these statutory deferrals under 600 point. I guess there's MCL 7691K or 771. The defendant was to comply with community corrections supervision and with Michigan Department of Health and Human Services foster care and neglect supervision terms. Matter was set for sentencing today. The defendant then was arrested for an incident that occurred in May where he assaulted someone else. And we received a notice that he had violated the bond conditions by engaging in assaultive or threatening behavior with Carrie Engelmeyer. The defendant admitted to the bond violation and did 4 days in jail. That was before this. So as a part of the plea agreement in this case, the assault on Carrie Engelmeyer was dismissed. The defendant entered a plea in this case, and then the matter continued on with a deferral. Somewhere in the summer, I gave him 4 days in jail for violating the bond conditions. It was alleged that on May 1st, he engaged in assaultive or threatening behavior by assaulting Carrie Engelmeyer. And as I indicated, that case was dismissed. So we're here on a deferral. I wasn't exactly clear in my notes what the terms of the deferral was. Ms. Camfield, I don't think was even here yet when this all went down, and she's tried to determine where we are. So Ms. Camfield, let me start with you.
Thank you, Your Honor. The notes from my chief assistant, Mr. Robert, indicate the following. In file 25513 SM, there was a plea to domestic violence first offense, setting this out 6 months. If there was no new criminal activity and there was compliance with Department of Health and Human Services treatment plan, then 25813 SM would be dismissed in its entirety, and 25513 SM would be reduced to a disturbing the peace. I think that's a little bit different from the court's notes, but that's all I have in the files at this point.
All right, well, my notes aren't in order here. There's 3 pages of them.
This was from June 19th.
June 19th, Josh Robert and Ross Truckee pleaded DV first, under advisement 6 months. That is in plead DV on Vicky Harbison 25513. Dismiss without prejudice at that time 25813. Divorce set for June 30th. There's a PPO from Carrie Engelmeyer. Defendant was in an accident and is still recovering, works at American Axle. Set for deferred sentence December 15th. I didn't make a note regarding disturbing the peace. But I think the other case was already dismissed. And so here we are. I don't know what's transpired since June 19th to now, or whether he's entitled to the consideration given by the prosecutor. I don't know whether there was input from the sister, but he broke her face. Mr. Truckee, what's the status here?
I'm sorry to interrupt real briefly. I did have an opportunity to speak with Vicky. She is present this morning.
Okay, good.
And she did wish to ask for, however this sentence goes forward, the no contact provision to be lifted so she can have contact with her brother again. There's been quite some time for them to reflect, for him to do some services and to modify behavior so that she feels she's forgiven him and would like to have that contact. As far as just before Mr. Truckee speaks, I'll let him go over his progress with the court. I don't know yet if I'm inclined to still recommend the DTP, but I wish to hear from counsel first on his client's progress.
Mr. Truckee?
Thank you, Your Honor. I represent, recently finished representing Mr. Engelmeyer in the child protective proceeding that's kind of intertwined with all of this. So I guess if we start at the beginning, in fall of 2024, he was in a severe automobile accident, ended up hospitalized for, I believe, three months or more, had some brain injury. He discharged from the hospital to Vicky's house. Vicky was helping her brother get on his feet. They get into an argument here in March, and the whole argument was about whether or not Kevin was having a relationship with his ex-wife and if he was continuing contact with Carrie Engelmeyer. They had a very volatile, toxic relationship for years that resulted in previous criminal instances, previous child neglect proceedings. Kevin finally did extricate himself from that mess after this accident, which was in no small part caused by Carrie Engelmeyer. He did divorce her. That went final over the summer of 2025. He's remained as free as possible of contact with her. She has reached out to him. She pursues him. She wrote a disturbing message on the office glass at my office. She's harassed him. That's part of why the other cases were dismissed as part of this plea deal, is it was an ongoing kind of rolling battle between Miss Engelmeyer toward Kevin. But since March of 2025, he's been substance free. I provided to the prosecution, I copied the court on as well, consistent drug testing multiple times a week with no positives. He participated in counseling. That was also provided to the court and the prosecution.
And I was interested in that because there was an underlying methamphetamine issue going on at the same time in 2024. He had a methamphetamine that was bound over to circuit court, and even though it was a felony, Judge Stutzman gave him 2 days credit, 2 days. So as part of the family case, he's been testing with the DRC?
Yes, and he's been clean from methamphetamine since his accident. The hospital stay, while it was troublesome, was a good natural break, and it allowed him to move on from that. So he participated, substantially complied with the...
When was the most recent testing?
I believe it was November 25th, Your Honor, and from that report, it showed that the results were still pending.
Let me pull up what I've got. I have tests from, there's well over 100 tests.
Which were all negative?
Yes.
All right, well, that's encouraging.
So he's maintained sobriety. He's continued to work on his emotional regulation. Today, he's scheduled for a last visit with his sons due to the family case resolving unfavorably for Mr. Engelmeyer. He's scheduled to see his sons today to kind of tell them how that goes.
Was there a trial?
There was. We had an all-day trial on December 8th. Took testimony from several witnesses. Judge Kane found in the state's favor. But not for lack of participation from Mr. Engelmeyer, really due to some other issues in overcoming the past trauma the children had suffered. So it does look weird when you look at this case. You say there's somebody, they got a fractured nasal bone, and it's his sister, and what's going on? But I think that Mr. Robert was abreast of the situation when he offered this, and Mr. Engelmeyer has held up his end of the deal. The only, if you were to characterize the bond violation as criminal activity, I suppose that could spoil the cake here, but I would submit that the former Mrs. Engelmeyer has been extremely persistent and erratic in her attempts to contact both Kevin and his father and others involved in this child welfare.
And her rights were terminated as well?
Yes, they were. She did not participate in the proceedings since January of last year. And I guess I would note, because of this, the state schedules this goodbye visit outside of my understanding. My appointment ends at the termination trial. I was not aware that was today until today. So if the court's inclined to order any jail, I think it'd be disastrous for the children and for Mr. Engelmeyer to have that interrupted.
Well, he also was referred to community corrections. And according to community corrections, he's been enrolled in the program since July 1st, given a deferred sentencing. He has remained in compliance, continued with his weekly call-ins, and remains otherwise compliant. So that as of December 14th, he has been in compliance with his community corrections obligation. So that was one of the conditions. And that's, so he's got negative tests. He's been compliant with community corrections. All right, I'm at the discretion of the prosecution. I'm looking for that judgment somewhere. I thought I'd given him 4 days, but that might have been on this case previously. He was in custody from March 21st to March 24th. And then I thought,
there were 2 pending matters with Mrs. Engelmeyer at that time, and it might have been assigned to one of those.
it may have been assigned in the 813 case. Ms. Canfield, what's your thought here?
Your Honor, this is a little bit of a challenging one. There is compliance as far as remaining sober since March. There were a lot of positive tests in March and prior, but he has remained sober since then, which is excellent. He is attending his therapy per the report provided by counsel. I will note, I do have some concerns about it in this respect, and let me get into that email. Open that up if I may. He is attending at Pivotal, which is great. That's where we would like him to be. My concerns are noted about halfway through, where he has a limited willingness to discuss past experiences or identify specific triggers related to his criminal matters and accusations, and is anxious and uncomfortable when talking about those things. It's hard to improve behavior or recognize triggers that lead to violence in order to stop having them if you're unwilling to acknowledge or address them. So you'll note why it says that his level of participation is good, his attendance is appropriate, that he attends appointments, the summary of progress is fair, as opposed to good or excellent because of that. And now we've got an additional significant stressor of a loss of parental rights. So I would frankly think it appropriate he hasn't had any new criminal conduct, but I don't think that the counseling has gone as well as it could have. I would like to see a short term of probation, 3 to 6 months, just to make sure that mental health compliance continues through what's going to be a very significant stressor today. I just am concerned about that. I understand why the deferral was provided. I have spoken with Vicky, who has forgiven her brother. I do think that at the very least, a couple weeks in custody, even served on weekends, would be appropriate for having broken someone's bones. I just don't know that there can be a full-out deferral and a reduction at some point without that type of a sanction. But I personally recommend to this court, as a long-time experienced domestic violence prosecutor, that it remain as a DV first with continued mental health compliance, and some jail.
What did he do between June 19th and now to violate the agreement? Mr. O'Bear took a deferred, and I don't like these, and I'm not going to do them anymore, but they made this deal that he would get a deferral if he cooperated with DHS, he complied with the terms of his community corrections obligations, and he continued to test negative. So you're punishing him for what he did in March, but they made this agreement in June that said we'll defer it. So what has he done between June 19th and now to violate the agreement for the deferral?
He's not addressing his triggers to violence with his therapist.
Where is that in the agreement?
It's in the report. Well, that's what DHHS considered to be non-compliant and why they moved forward with the termination of parental rights. That was part of that hearing. In addition to, they felt he couldn't parent the children versus being a friend to the children. So, you know, that's not full compliance with DHHS if they feel they have to move forward with termination.
I believe that's a mischaracterization. There's also statutory timeframes. There's guidance that applies in those cases, regardless of progress after a certain time.
I'm well aware of statutory timeframes and moving the child for permanency. I get it. I understand that, Your Honor, but the counselor says he is not addressing triggers to these traumatic events. If somebody's not addressing their triggers, they cannot improve and avoid that behavior in the future if they won't identify what they are. We're gonna end up in a situation where there's just more violence, particularly with the stressor today.
Well, this was a crappy deal made by your office then. And so I'm trying to find a hook to hang my head on here.
I mean, it's the discretion of the court, obviously, Your Honor, but that's just my position, having referenced the records that I have.
Would this entail reauthorizing the earlier charge, 25813?
No, I would not do that.
Mr. Truckee, your response?
I note that counseling takes as long as counseling takes, first of all. And second of all, the divorce judgment regarding the former Mrs. Engelmeyer is the biggest trigger reduction there is. If you were to look through the history, this has a different complainant on it, but the conversation that led to it was a confrontation about Mrs. Engelmeyer. She has been the trigger for Mr. Engelmeyer for 13 years or thereabouts. So I'd ask the court to consider the legal steps he's taken to separate himself from her and the harm or the risk reduction that occurs now that he's done so. And Ms. Harbison is present at the court lecture.
Yes, I'll accept your representation as you wish the prosecution to go ahead with the agreement for disturbing the peace.
Yes. I do.
And you'd like to lift the no contact provision so you could have contact with your brother. Has he had contact with you since June?
Speak through his girlfriend, Laura.
Who's the girlfriend? Or, okay, she's been here through all of this. I want to call you by your maiden name, but I'm not sure what your name is now. Do you wish to speak? Yes, why don't you come up to the podium? All right, would you state your name?
My name is Laura Norman.
What's your last name? Norman, that's
Norman.
right, Norman. And you're no longer with Mr. Norman, you're now with Mr. Engelmeyer? Since when?
Since February.
So before all this stuff happened, you were with him, I think, at his original arraignment. All right, so are you living in the same house?
Yep. Yes, he lives with me in Waterloo.
All right, do you have children?
Yep. Yeah.
And where are your children?
3 live with me. 1 lives with their dad, and 1 is my oldest is grown up and living on her own in Sturgis.
You realize how old that makes me feel? All right, so he's living with you and 3 of your children. Is that yes?
Yes. Yes. Sorry.
All right, what would you like me to know?
1, that in his accident, his adrenal gland was damaged, which is also responsible for your cortisol levels and your fight or flight response, which as he was living with his sister, he was still recovering from his accident. And that's what she knew when she took him on, which is why she didn't want to originally press charges, because she knew he was recovering. As well as I wanted you to know that not only is he going to counseling with Pivotal, but me and him also have our own counselor that I don't know what she does on her day job. It's like a drug
All right, so
counselor.
even
but we
after-
see her
Even
every
after the
Friday.
abuse neglect case, he's still in counseling with Pivotal?
Yes.
Yeah.
All right, and you and he are in couples counseling?
Yeah, just to make sure that we have a good relationship and being proactive to make sure, because neither of
And
us have had
who
good
is he
relationships.
who are you 2 in counseling with?
Faith Shreve,
Say that again?
Faith Shreve.
All right, who's she through?
It's her own private practice. I believe.
And you would be in a position to know, since March, has he been using methamphetamine
No.
or any other
He
drugs?
is completely clean. He is amazing with my kids. He is still quiet like he was when we were friends in high school. I do believe Carrie has been I think he was in a domestic violence relationship, but I believe that it was him that was the victim of domestic violence for the past 14 years.
All right, thank you. You can have a seat.
Thank you.
I find that the defendant is substantially in compliance with the deferral agreement that he made in June. He did continue with his CPS. He's tested negative since March. He continues in counseling with Pivotal, and he's also apparently in couples counseling. Even though he's done with the PS case. He also did 6 days in jail, 2 days at the front end and 4 days for the bond violation. Order 6 days, credit 6 days on the disturbing the peace deferral plea. I don't feel a need for a probation. There is a $75 fine, $75 crime victims' rights fee, $50 state minimum fee, and $150 attorney fee. That's $350. The defendant does have $100 of bond. So you have $250. Are you back to work at American Axle?
Yes.
All right, I'm gonna give you till February 15th of 26 to pay that. You're certainly in a better place now than you were in March, but it is about as bitter of a pill as it is to have your parental rights terminated and then have a meeting to say goodbye. I can't even conceive how sad that would be, but I've seen it. All right, this matter is completed.
Thank you, Your Honor.
Thank you.
Thank you,
Take
Your
care of yourself, all right?
All right, I'm late for a meeting. No
Figure out what
lunch.
you're gonna say this afternoon. Huh? Stop through. We get that people.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Take care.
Well, ladies and gentlemen, it has been a crazy night. Been an interesting night. We've suffered through some internet hiccups. I'm going to be working on that again tomorrow. Hopefully we won't have another issue similar to this one. But hey, what we didn't watch tonight, we'll watch later. For those of you who don't know, we have a big honking chunk of the Thurston County anti-harassment calendar on deck at some point in the very near future. But for now, ladies and gentlemen, I just want to say thank you very much for tuning in. I am your humble Lone Wolf Usul. I am your host for these here videos, and I'm your curator for this here channel, Lone Wolf Usul's Court Gallery. Come on by here every single night at 8 p.m. Central Time, 9 p.m. Eastern Time. I'll be right here hanging out, showing some court videos. You can talk about those videos with me. I feel like I used as few punctuation points in that last sentence as a few of our previous defendants in former cases. Maybe possibly even Judge Rossi himself. Ladies and gentlemen, thank you for tuning in. We'll leave you with the music and say have a great night. I appreciate you very much. I'm your Lone Wolf Usul. I'm out. Good night, everybody.